Good morning. I want to welcome you today to this webinar on Proposition 19, one of the most discussed and confusing propositions we've seen in a long time. Before we get started, I want to thank over a dozen title companies and realtors and other folks that have assisted us in putting together this presentation today. You know, to date, I have given, I think this is the 6th presentation on Proposition 19. So we've had well over 1,000 individuals who have registered for one of these presentations. So if you have attended an earlier session, I want to apologize in advance, as some of this material will be repetitive. Unlike prior webinars, which focused almost exclusively on the narrowing of the parent-to-child property tax exclusions, this session will be broader and an overview of Proposition 19. You know, my staff and I will provide the most up-to-date information on the current status of legislation and insights from the State Board of Equalization. Assuming most people on this webinar do not have regular contact with an assessor's office, I want to provide you with some basic information about my office. Every 5 years, we're audited by the State Board of Equalization. In the 4 BOE audits during my 26-year tenure as the assessor, the accuracy of our assessments have met BOE standards 98 to 99%. During my term in office, the assessment roll has increased 379%, from $115 billion in 1995 to $551 billion in 2020. My staff has increased only 4.5% during those 26 years. Santa Clara County employment, however, has increased 64% during the same period. We have returned $21.3 million of the assessor's budget back to the county general fund unspent. In other words, I've underspent my budget in 25 of 26 years. The results of all of this is nearly $6 billion in property tax revenue each year for schools and local government. You know, the context is important for understanding Proposition 19. Assessed values have become valuable unto themselves. With the passage of Proposition 13 in 1978, assessed values are no longer market-driven. Instead, assessments are based upon the purchase price at a change of ownership or new construction, and then increase by no more than 2% each year. As a result, assessed values over time are far less than market values. One's low assessment has become a prized asset, cherished by longtime homeowners and envied and even despised by younger first-time homeowner wannabes. Over time, California voters have approved several ballot measures and initiatives intended to retain low assessments, even passing assessed values to their children, and in some cases, even their grandchildren. Proposition 19 is the latest effort in this regard, but it, unlike its predecessors, was terribly written. Attendance today at this webinar is overwhelming. I think we have over 1,000 people that have registered. And while I'm pleased my office is sponsoring this event, candidly, I wish it wasn't necessary. For more than 2 decades, I have administered the property tax system in Santa Clara County based upon a simple premise that there were clear rules of the road. Proposition 19 contains major changes to the state constitution, overhauling or eliminating 5 previous initiatives. Many of the provisions are confusing, ambiguous, and conflict with the initial intent. To make matters worse, the legislature has been unwilling to pass comprehensive implementing statutes. Instead, the legislature has offered just a handful of fixes, which are still awaiting passage. To understand where we are today, it's important to know how we got here. For decades, with little success, there have been attempts to expand Proposition 60, the initiative passed in 1986, which enables homeowners over the very old age of 55 to transfer their coveted assessed value to another home of equal or lesser value without reassessment to market value. Prop 60, principally designed for empty nesters wishing to downsize, is relatively straightforward. 2 years later, the voters passed Proposition 90, expanding this benefit to other counties. However, the inter-county transfer allowed each county to choose whether to participate. Well, it's not surprising only 10 counties out of 58 agreed to accept Proposition 90 transfers. The reason? The loss of property tax revenue, of course. So why did Santa Clara County opt in and accept Proposition 90 transfers? Well, raw political pressure on the Board of Supervisors at that time. In 2008, Florida voters passed Amendment 1, known as Save Our Homes, championed by Florida State House Speaker at the time, Marco Rubio, which allowed homeowners, just like Proposition 19, to retain lower property taxes when they moved to a new home. Proposition 19 was initiated by the California Realtors Association for the same reason, because it would create more transactions and therefore more real estate commissions. Encouraged by the success in Florida, the Realtors Association began pushing for a universal Prop 90, allowing transfers to all 58 counties. The Realtors' proposal, however, was a non-starter for parents and others concerned about the huge loss in revenue, estimated by the Legislative Analyst's Office to be $1 billion a year, negatively impacting funding for schools and local government. Well, undeterred, California Realtors mounted a campaign to collect signatures to qualify Proposition 5 for the November 2018 ballot. Proposition 5 also allowed homeowners over 55 to purchase a larger, more expensive home in any of the 58 California counties and retain most of their property tax benefits, defeating, I think, the original intent to assist empty nesters, seniors who wanted to downsize from a larger home or enable grandma to get closer to the grandkids. Proposition 5 failed by a margin of 60 to 40 because Californians are not Floridians. Cutting funding for public education was of bigger concern than an additional tax cut for longtime property owners like me, already benefiting from Proposition 13. In addition, the firefighters and teachers unions threatened to fund a campaign to defeat Proposition 5. Realtors argue seniors living in high-valued homes with low assessments are trapped in their homes, and Proposition 19 frees them from this financial burden. Well, actually, first-time homebuyers are the ones trapped out of home ownership. Firefighters and teachers unions told the realtors that unless they found the revenue to offset the loss, they would once again fund a campaign to defeat a new proposition, just as they had successfully defeated Proposition 5. So California realtors had to find a major source of new revenue to pay for the huge loss in revenue created by a universal Prop 90, available in all 58 counties. They decided on eliminating a tax loophole, the exclusion from reassessment of parent-to-child transfers. In 2017, the California's Independent Legislative Analyst's Office issued a scathing report on the inheritance exclusion, which was Proposition 58, whereby children are able to inherit their parents' principal residence and retain their low assessed value. The LAO estimated that 60 to 80,000 property owners have received this benefit at a cost of as much as $1.5 billion in lost property tax revenue annually. In addition to the transfer of the principal residence, Proposition 58 also allowed the transfer of additional property assessed at $1 million. The LA Times did a serious investigation revealing the unfairness of this loophole. The Times reported how celebrities Bo and Jeff Bridges had inherited a 4-bedroom Malibu home from their actor father, Lloyd Bridges, with access to a semi-private beach and panoramic views of the Pacific Ocean. The investigation revealed that the Bridges rented the home for $16,000 a month and paid approximately $5,000 a year in property tax. Frankly, California realtors did not care much at all about this part of Proposition 19. They just needed to find $1 billion to offset the $1 billion lost from a universal Prop 90. Almost immediately, assessors and other powerful interests, like the California Farm Bureau, identified major problems with the language of Proposition 19. Farmers who historically passed the family farm from generation to generation recognized immediately that they would be big losers. Ironically, they may still be. With major political problems building and the likelihood of an organized, well-funded opposition from farmers and labor unions, the realtors asked the legislature to step in and fix the problem. As a sweetener to moderate Democrats, hesitant to support a tax increase, they promised that the revenue would be allocated with a special and very convoluted formula that would likely benefit rural counties over urban counties. In just 6 days, this half-baked Proposition 19 passed the legislature, mostly behind closed doors. It was so late in securing legislative approval that the governor had to step in and sign special legislation tolling the required deadline in which an initiative must be approved by the legislature. The result is the mess we're now dealing with, Proposition 19. Regardless of what you think about Proposition 19, which I actually voted for, it is the law of the land in California. As your assessor, I'm committed to making sure it is well understood and that taxpayers receive the maximum benefit allowed. It is why California assessors and the State Board of Equalization have been scrambling to try to interpret Proposition 19 and determine how we will implement it. More than anything, assessors want to ensure we uniformly and fairly implement all tax laws. Equal application is not just a goal for assessors, it's a fundamental axiom. A property should receive the same treatment no matter where it's located. Subject matter experts in assessors' offices from Los Angeles, San Bernardino, San Luis Obispo, Kings, and Santa Clara counties, together with the State Board of Equalization, have been meeting weekly, sometimes daily, to clarify and identify problems that must be addressed by the legislature and the State Board of Equalization. Unfortunately, the legislature, limited by COVID-19, determined that they could not consider such a major piece of legislation and pass it by the February 15th deadline for implementation of parent-to-child transfers. After enormous political arm twisting, assessors in the BOE were successful in persuading the legislature to introduce SB 539, nicknamed the Skinny Bill, which was largely drafted by assessors and State Board of Equalization staff. It provides the absolute minimum legal backstop that assessors require to administer the parent-to-child transfers of Proposition 19. There's almost nothing in SB 539 concerning other portions of Proposition 19, which we will address today. It is not ideal, but if passed, it will provide some of the desired legal authority for assessors and the BOE to act uniformly. Effective April 1st of this year, the other sections of Proposition 19 become operable. These permit eligible homeowners, defined as over the age of 55, severely disabled, or homes destroyed by wildfire or disasters, to transfer their primary home's assessment to a replacement resident of any value anywhere in the state. The math is relatively straightforward. Essentially, if your new home is purchased for the same amount or less of your prior home, your low assessed value will not change. If the market value of your new home is more than the sales price of your old home, the difference is added to the assessed value of your old home. Let me give you an example with my own home. In 1975, I purchased my current home in Sunnyvale, a 3,000 square foot modest tract house on a 10,000 square foot lot for $85,000. It's currently assessed at $276,000. Zillow says the market value of my home is $3 million. As long as a new home has a market value of $3 million or less, my $276,000 existing assessment transfers to my new home. However, if I buy a new home for, say, $4 million, then my assessment jumps from $276,000 to $1,276,000. Assessors look to the marketplace to determine the market value of both homes. Assessors must assess property, all property, at fair market value. So how does the assessor determine market value? Usually, the sales and purchase prices are accepted, but they must reflect the current fair market value of the homes. If for some reason the price does not reflect the actual fair market value, the appraiser will determine a different value, and we will use the fair market value of the appraisal's determination. To simplify the process, we have created a new electronic calculator to help homeowners estimate their new assessments. In addition, and pending clarity from the Legislature and the State Board of Equalization, Proposition 19 allows eligible homeowners to keep their low property assessment when moving to another home anywhere in the state. Use special rules to move to a more expensive home. The property tax bill would increase, but not near as much as it would for non-Prop 19 transfers. Use these special rules a maximum of 3 times in their lifetime. Proposition 60 and Proposition 90 sunset on March 31st of this year. To receive the expanded portability of Proposition 19, homeowners must complete at least one of the transactions on or after April 1st. Let me repeat that. You do not need to wait until after April 1st to be eligible for these provisions of Proposition 19. At the insistence of assessors and the BOE, SB 539 makes it explicit that only one transaction must occur after April 1st. Property owners have 2 years from the transfer of the first property to complete the second transaction. Proposition 19 also supplements existing transfers for victims of wildfires or disasters or owners who are severely disabled. Upon implementation, taxpayers will have to determine and apply for those provisions which are most advantageous for their particular circumstance. Effective February 16th of this year, Proposition 19 substantially narrowed the property tax benefits for inherited properties. Simply, the measure restricted the assessed value that can be transferred to 2 kinds of inherited property. Property used continuously, continuously, by the child or grandchild as the primary residence, or a property held as a family farm. The measure has a convoluted formula to qualify and to compute the benefit. Basically, assessed values of an inherited home or farm would increase if the market value exceeds the property's base year value by more than $1 million, adjusted for inflation every 2 years. Well, Nora Galvez, who is one of the leading experts in California on the transfers of ownership, will go into greater detail about the mechanics of that formula. To make things easier, I think, our office has developed an electronic calculator that will enable residents to calculate the savings. The biggest change was the elimination of Proposition 58 and Proposition 193 from the state constitution, which provided generous property tax benefits to inheritors of homes and commercial properties. That is gone as of February 16th of this year. Nora and Deputy Assessor David Ginsburg will explain what we know and how we plan to administer Proposition 19. My office has created a robust website that includes legal opinions, new forms, and other information that will help all of you make informed decisions. In closing, it is our intention to provide a general summary of Proposition 19 today. It is not intended to be an absolute legal interpretation. Proposition 19 is a constitutional amendment, so additional legislation, regulations, and state guidance is necessary to clarify its implementation. If there's a conflict between information provided here today and the proposition, or any legal authorities implementing or interpreting the proposition, the text of Proposition 19 will prevail. And finally, I want to remind everyone that we will do our best to provide general guidance. However, our office does not provide legal advice to specific situations. And now I'd like to turn it over to my Deputy Assessor, David Ginsburg, to talk about the current status of legislation and rules and guidance on Proposition 19. In addition, he will go into details about the base year transfer and components of Proposition 19. He will be followed by Nora Galvez, who will go into detail about the parent-to-child portions of Proposition 19. And also with us today is Debbie Chavez, one of my appraisers who helps administer Proposition 60 and 90, and will be assisting with Prop 19 implementation and questions. And lastly, we have someone from the county recorder's office to help in any questions you may have. So David.
Thank you, Larry. And thank you again to everyone for joining us today. Before I begin, I am putting on the screen the official legalese. Basically, we're doing our best to interpret the changes to the Constitution made by Proposition 19 in the absence of clear direction. Our guidance today is our best faith effort and is subject to change. All right, now that we've gotten that over with, let's get into it. Current legal status. Unfortunately, the initiative is ambiguous, confusing, and unclear. This is not just my opinion. Legislative committee staff commented that, and I quote, "Many of the Act's terms and requirements are unclear or conflict with other parts of state law." Similarly, the Board of Equalization staff noted, quote, "In the absence of implementing statutes, Board of Equalization rules, or court decisions, each of the 58 assessors are on their own to interpret Proposition 19. Just as giving an idea of the confusion, in December, the Board of Equalization provided advice to assessors that, upon reflection, was a few weeks later superseded by other advice provided by the Board of Equalization in January. They made a best faith effort, they recognized, and then they had to adjust that advice. And in the absence of implementing statutes, Board of Equalization rules, or court decision, each of the 58 assessors are on their own to interpret Proposition 19. So assessors recognized this problem immediately, and the California Assessors Association stepped into the breach. They are comprised of all 58 assessors who, by nature, tend to be subject matter experts and professional administrators. While elected constitutional officers with their own strong political beliefs, they are not politicians. They do not believe there is a red way or a blue way to administer the property tax law. The association met immediately following passage of Proposition 19 and formed an ad hoc committee of 6 counties to investigate options and provide recommendations. The committee formed a partnership with the Board of Equalization, which developed a gap analysis designed to look at the language in the initiative and the laws or rules needed to implement Proposition 19. The result was a 45-page document. Passing implementing statute was deemed the most highest priority. And with the encouragement of the state legislature, the committee worked over the holidays and Christmas time to draft a more than 30-page document with specific proposed statutes. So what is the current status of legislation? Unfortunately, the complexity of the proposal and COVID's impact on the legislative process, combined with February 15th implementation date for the intergenerational portion of the law, resulted in the legislature asking the association to develop a stopgap measure, which Larry referred to earlier as the skinny bill. Despite the deadline and urging by the assessors and the Board of Equalization, the legislature did not introduce the skinny bill. The legislature introduced the skinny bill, which is now SB 539, but it was not introduced until February 18th. SB 539 focused almost exclusively on the intergenerational portion of Proposition 19. Some of the things it does includes requiring the family home to be the principal residence of the transferor and for the transferee to occupy the family home as a principal residence within 1 year of the transfer, excluding the family farm from requiring to be the principal residence, permitting the Board of Equalization to pass emergency regulations. This legislation is winding its way through the state legislature and has already passed its first 2 committees in the state Senate unanimously. The only other introduced legislation, SB 668, proposed delaying implementation for several years, which on its face is directly contrary to the explicit start dates in Proposition 19. Because it is likely unconstitutional, SB 668 has stalled in the state legislature. So where do we go from here? Well, simultaneously, the assessors have been working with the Board of Equalization On March 4th, a draft rule concerning exclusively the intergenerational portion of the law was introduced. It is 11 pages and very detailed. Unfortunately, it will take 12 to 15 months before it becomes a binding rule, assuming it passes all the hearings and votes and things like that. In the interim, the board has done a tremendous job of drafting guidelines and legal opinions, again focused on the intergenerational sections, as those are already being implemented by assessors. The board has also provided 7 new forms for assessors, and all of this was developed in close coordination with the California Assessors Association. This information is on our website, and it's also on the Board of Equalization's website. And while none of this information is binding on assessors, assessors are working closely together to administer it uniformly. For the remainder of my presentation, I will be focusing on the base year transfer of the law, which takes effect on April 1. Following me, Nora will speak about the intergenerational portion of the law. So, SB 539, as I mentioned, there is very little in it concerning the base year transfer portion of the law. Thankfully, and I know it's a big issue for many on this webinar, thankfully SB 539 does clarify that only one of the 2 transactions must occur after April 1. What's not in the bill is far more disconcerting. For example, the laws that implement Proposition 60 and 90 remain on the books until the state legislature takes them out. Now, the Constitution says that the Proposition 19 invalidates them. So they expire on March 31st, even though they remain on the legislative books. Plus, there's no guide to assessors concerning the disaster provisions. In the absence of legislation or rules, the assessors plan to implement in the same fashion as Proposition 6090. In the next 30 days, the board is creating guidance and draft rules. Thankfully, they've already created the forms and they are now on our website. Simultaneously, the assessors are urging legislators to pass a comprehensive bill to address all the remaining gaps. The assessor went over the essential requirements to qualify for the base year transfers after April 1. Let me walk you through 2 examples to illustrate how this will be calculated. In example 1, the assessed value is $300,000. The homeowner sells their home for $900,000 and buys a new home for $700,000. As the market value is equal, or in this example, lesser than the sale price, the taxable value of $300,000 is transferred to the new home. In the second example, they sell the same home and buy a new home for $1.4 million. The assessed value increases to $800,000. The difference between the purchase price of $1.4 million and the sale price of $900,000 is $500,000, which is then added to the assessed value of $300,000 to arrive at the $800,000. We anticipate having a new online calculator for the base year transfer by April 1 to help taxpayers planning to transfer their assessed value. Finally, I would like to briefly touch on Proposition 19's assistance for victims of wildfire or natural disasters. Unlike other portions of the law, these new provisions do not replace, but rather supplement existing tax benefits for qualifying victims of wildfires or natural disasters. Depending upon your circumstances, it can provide more expansive benefit, and in other situations, it can be more restrictive than existing law. For example, Prop 19 allows less time to apply, which can be a real problem when you're trying to sell a burned down home. Plus, the relief in Prop 19 is limited only to damaged buildings and does not include damage to the land, like a landslide. In the next few minutes, I plan to go over a handful of the most commonly asked questions submitted when you registered. So let me start with the first question. If I've already sold my original property and will purchase my replacement property after April 1, will I qualify under the new Proposition 19 rules? The answer is yes. Only one of the transactions must occur after April 1. That is how our office will be implementing the law, and every assessor in California, regardless of whether or not the SB 539 has passed by April 1, that is how we will be implementing the law. Next question. If the assessor denied a prior year transfer because my purchase was greater than the sale price of my original property, can I try again under the new Proposition 19 rules? No. At least one of the transactions must be after the April 1, 21 effective date. There has been a lot of confusion about the time limits. One place says there is a 2-year limit, another 3 years. So these time limits are dealing with two different issues. The 2 years is about how much time is allowed between when the replacement residence is purchased or newly constructed and the sale of the original residence. The 3 years concerns the application process. The Prop 19 application must be filed within 3 years of the date the replacement residence is purchased or newly constructed in order to receive full benefits. If the application is filed after 3 years, only prospective relief will be granted. Next question. If I've sold my home and bought my new home in Santa Clara County in June 2021, and it takes 6 to 18 months to process, how much taxes do I pay in the interim? The tax bill will be based on the purchase price until the application is approved. Once the application is approved, taxpayers will receive a credit or refund from the tax collector for any overpayments. In the past, the typical turnaround time was 3 to 4 months. The longest delays are transfers in the beginning of the year because of the timing of the close of the assessment roll or waiting for assessed values from other counties. As you can imagine, right now we're asking for taxpayers' patience. Not only do we expect an increase in requests for base year transfers, we are also working quickly to set up a new procedures and processes. While our county has experience with transferring base year values to other counties, which is time-consuming and laborious, 48 counties have never processed a transfer from another county. As a result, our county may be delayed in approving applications due to staffing and implementation challenges faced by other counties. The speed by which these counties process transfers will impact our ability to provide our normal timely approvals, and we apologize in advance for that potential delay. Next question. Is it okay to put another person on title? Yes, the claimant needs to be on title in some percentage on both the original and replacement residence. Next question. If the qualifying homeowner has a minority interest in the property, can they transfer 100% of the benefit? Yes, they can. It doesn't matter what percentage you own. You only have to be on title of the property that is sold and the property that is purchased. Next question. I have never applied for a homeowner's exemption, but I'd lived in my house for many years before I sold it. Can I still qualify? Sure you can. As long as the homeowner can prove that the sold property was owned and occupied as the principal place of residence. How long do I have to live in a house before it is considered a principal residence is the next question. There is no time requirement, but you must be able to show that it truly was your principal permanent home. Next question. I am purchasing a new residence and plan to rent it out for a year or possibly remodel it before I move into it when I sell my original home. Will I still qualify for Prop 19? Yes, assuming you meet all other qualification requirements. Next question. What if I rent out my original house for a year, sell it, and then buy a replacement residence? Can I apply? Yes, as long as the original property is sold within 2 years of purchasing your replacement property and the original property was eligible for the homeowner's exemption, either the time of sale or within 2 years of the purchase or new construction of replacement dwelling. Next question. I think my realtor or title company already took care of filling out the application. People have asked, is this effectively an automatic grant of the transfer? And the answer is no. It's great that realtors are maybe assisting, but it's not a guarantee that the base year transfer has been approved by our office. It's important that the application filed is submitted with the assessor where the replacement property is purchased. A copy of a driver's license or birth certificate should be attached. If you're not sure if you filed an application, you can call, or even better yet, email our office. Next question. I previously transferred my home under Prop 60. Can I transfer again under Prop 19? And if so, how many times? Yes, you can, and you can do that up to 3 times. Next question. Which date does the assessor use to determine the base year transfer? The assessor's office will use the latest of the following dates: the date the original property is sold, the date the replacement property is purchased, or the date the new construction of the replacement property is completed. We were providing an example where a taxpayer purchased a replacement dwelling in March 2020 and then sold the original home this November. In this example, the taxpayer is responsible for the increased taxes from the time the replacement property was purchased until the original property was sold. Next question. I bought a vacant lot 10 years ago. Excuse me one moment, just getting my order here. I bought a vacant lot 10 years ago. I want to sell my present home and build a new one on the vacant lot that I already own. Would I qualify for Proposition 19? Yes, as long as the date of the completion of the new construction is within 2 years of the sale of the original house. The assessor's office will do a market appraisal as of the date of completion of the new construction, including the land of what the new house would sell for. The market value for the land improvements is what the appraiser used to compare with the sale of the original house. Next question has to do with severely disabled. Like the existing disability requirements, the applicant's physician must complete a certificate of disability indicating that their severe disability requires them to move to a new residence that meets the needs of their disability. The assessor's office will provide you a certificate along with the application for the Prop 19 or Proposition 110 transfer. The most common request for a transfer for disability is moving from a two-story home to a single-story home. The term severely disabled is unique to Prop 19 and is an example where there remains ambiguity. The current law requires someone to be permanently and severely disabled. Under Prop 19, it is unclear what qualifies someone as severely disabled and what happens when someone is no longer severely disabled. Next question. Can I transfer my tax base to a manufactured home? Yes, but it may not be advantageous because manufactured homes are typically lower cost. Next question. If I apply in April, how long does it take to process the application? Well, as in past years, transactions that occur after January will not begin to be processed until after July. As we are saying, new processes and procedures, we have no way to know for sure how long it will take to process. Next question. Would I still qualify for Prop 19 benefits if I were just a few months shy of age 55 when my property sold, but over 55 when I purchased my replacement? No, this is key. You must be at least 55 when your original property sells. While you may be 54 when you purchase your replacement property, you must be at least 55 when you sell your original property. Next question. What form do you need to complete to receive the base year transfer benefit? You do not need to fill out any forms or notify the assessor's office of your sale or purchase until you close escrow on both properties. Once both properties have closed escrows, you can download an application from the assessor's website in which your replacement property is purchased. Please mail the original application with a copy of your driver's license and any applicable fees to your local assessor's office. You do not need to include copies of escrow documents or deeds. We verify everything internally. Next question. My spouse and I just got a divorce. We're going to sell the house that we bought together, and I plan to buy a new house. Can I transfer the tax base, or am I only able to transfer half of it? Well, the tax base cannot be split. Only one spouse can transfer the entire tax base. Whichever spouse completes the application first receives the base year transfer. And finally, do we anticipate charging a fee to process base year transfers like we do currently with Proposition 90? Yes. For Prop 19, we anticipate charging the same filing fee of $110. And with that, what I'm going to do is I am now going to turn this over to, I'm going to stop sharing and turn this over to Nora, who is going to lead us in the next round of presentations.
Good morning, everyone. And I just shared my screen. I hope you all can see it. If you cannot see it, please let me know so that I can try to make adjustments. And as David stated, I am going to talk to you in regards the new provisions under Proposition 19 and the changes that made to Proposition 58, the parent to child exclusion, and also the grandparent to grandchild exclusion. Okay, so let's begin. So as you all know, on November 3rd, 2020, California voters approved Proposition 19. Proposition 19 adds Section 2.1, 2.2, and 2.3 to Article 13.8 of the California Constitution. Also, it changes provisions, like I mentioned, on the parent and child and the grandparent to grandchild exclusions, effective February 16, 2021. But it also adds new provisions for base year transfers, effective February 1st, 2021. Proposition 19 also limits exclusions only to family farms or family homes. The family home needs to be the principal residence of both the transferor and the transferee, and also adds a value test for a family home, which is the factor base year value, the assessed value, plus $1 million. And I'll show you an example of this in a little bit. One of the biggest changes that Proposition 19 is making, it repealed the former parent to child and grandparent to grandchild exclusions by making inoperative provisions to the Constitution that were added by Proposition 58 and 193 in 1986 and in 1996, respectively, as implemented under Revenue and Taxation Code Section 63.1. So let's just go over really quickly on the provisions on Proposition 58, the parent to child exclusions. Proposition 58 was effective on November 6, 1986, and it's codified by Section 63.1 of the Revenue and Taxation Code. Under Proposition 58, the child or the parents can transfer principal residence between parents and the children without any reassessment, regardless of the value. There were no restrictions on use of the property after the transfer. So it could be the principal residence, it could be a commercial property, income property. So there was no restrictions on that. Proposition 58 also allowed for transfers up to $1 million in assessed value of properties where they're not the principal residence of the transferor without any reassessment. The grandparent to grandchild exclusion was effective 10 years after Proposition 58 on March 27, 1996. Also is codified by Section 63.1 of the Revenue and Taxation Code. Under grandparent to grandchild exclusions, transfers of principal residence are allowed, but it's only one way, only grandparent to grandchildren without any reassessment, regardless of the value. There are also no restrictions of the use of the property after the transfer. And something with grandparent to grandchild under the provision, Section 63.1, states that in order for the grandchildren to qualify for this exclusion, the parents of the grandchild must be deceased as of the date of the transfer. A lot of the people are asking us whether we're still implementing these provisions. And the answer is yes, but only for those transfers that are February 15 or prior. They're no longer effective on February 16 or after. Let me just show you really quickly the difference for Proposition 58-193 and Proposition 19. Well, as I mentioned, under Proposition 58-193, transfers of principal residence between parents and children without reassessment are allowed. Under Proposition 19, the value is limited of the current taxable value plus that $1 million. Proposition 58-193, there's no restrictions of the use of the property. Under Proposition 19, the home, the family home, must be the transferee's principal residence. Under Proposition 58-193, there's no longer the $1 million in assessed value for properties that are not the principal residence. Under Proposition 19, only the principal residence is eligible. So there's no more income property or commercial property. Only the principal residence is eligible under Proposition 19. There are also some filing requirements under Proposition 19. The transferee must claim the homeowners or disabled veterans exemption at the time of the purchase or the transfer of the family home. If the claim form is not filed at the time of the purchase of the transferee has 1 year from the date of the purchase of the transfer to file the claim form in order for them to qualify. Same way as Proposition 58-193, a claim form must be filed in order to receive the exclusion. Proposition 58 comes with a value test. The value test has 4 steps that we need to follow. Step number 1, we need to calculate the sum of the factor-based year value, the assessed value, plus $1 million. Step number 2, we need to determine whether the assessed value exceeds the sum of the factor-based year value and the $1 million. Step number 3 is asking us to calculate the difference. And the last step is asking us to add the difference to the current assessed value, the factor-based year value, to be able to come up with the new combined base year value. So let me give you an example of this. Let's just say that we have a single family residence that has a factor-based year value of $200,000. The parent dies on March 1st, 2021, and the property is inherited by the parent's only child. It just happens that the property is the principal residence of both the parent and the child. On the parent's date of death, the property has a fair market value of $1.8 million. So let's apply the 4 steps of this value test. So step number 1, let's calculate the sum of the factor-based year value plus $1 million. As you can see, is 1.2. Step number 2, we need to determine which one is greater, the fair market value or the sum of the factor-based year value plus $1 million. As you can see, the fair market value, $1.8 million, is greater. Then we need to calculate the difference. The difference between these two values is $600,000. Now that difference, we need to add it to the factor-based year value to be able to come up with the new combined base year value. And in this example, it is $800,000, which is the new combined base year value. Okay, so that's how we are going to be working these transfers under Proposition 19. I have a few questions for you that we have received and that they're pretty much most commonly asked questions. So let's look at this first question. Is Proposition 19 retroactive and would it cause property transfers that have already received the benefit of Proposition 58 to be reassessed? And the answer is no. Proposition 19 is clear that Proposition 58 applies to transfers that occur on or before February 15, 2021. And Proposition 19 applies to those transfers that occur on February 16, 2021 or after. Question number 2. If a parent died prior to the February 16, 2021 date, and the assessor does not become aware of the death until a year later and reassesses the property as of the date of death, are the parent-child exclusion provisions apply under Prop 58 or is it a Proposition 19 provisions? The answer is the date of death is the date of the change in ownership. So the law in effect as of the date of death would apply. So if the parent died prior to, on February 15 or prior, we're going to apply the provisions under Proposition 58. However, if the parent passed away on or after February 16, 2021, we're going to apply Proposition 19 provisions. Okay, so this is a very commonly asked question, and I believe I saw it in the chat also, in the Q&A, I'm sorry. So I have a deed signed and notarized, and I have submitted it to the recorder's office prior to the February 15, 2021 deadline. What if my deed does not record by the February 15, 2021 deadline? Must my deed be recorded prior to the date in order to still be under Proposition 58-193 provisions? And the answer is no, as long as the date of transfer is on or before February 15, 2021. And the transfer will be able to qualify for under the provisions of Proposition 58-193. We do have a property tax rule, which is 462.260, that makes it very clear that the recording date of a deed is rebutably presumed to be the transfer date. So this means that if evidence is shown that the transfer occurred prior to the recordation date, we're going to apply that date. And a good example of this is the notary date. So the notary date, if the document was notarized prior to February 15, 2021, we are going to apply Proposition 58 and Proposition 193 provisions. Are transfers of family homes through the median of trust eligible for Proposition 19 exclusion? The answer is yes, and it doesn't matter what kind of trust we're dealing with: living trust, irrevocable trust, testamentary trust, sub-trust, a special needs trust. For property tax purposes, we look through the trust to determine who has the present beneficial ownership of that trust. Therefore, if all requirements are satisfied, transfers to and from a trust are eligible for the exclusion. Question number 5. Does Proposition 19 make any changes to the ability of trustees to equalize distributions of estate property trust that provides that the children are to receive the trust assets on a share and share alike provisions? Like I mentioned, Proposition 19 does not change the property tax rules surrounding the operation of a trust, including trusts with share and share alike provisions. However, something to consider here is that after February 15, 2021, only the family home and family farm may be excluded from changing ownership. No longer under Proposition 19, we are no longer excluding those properties that is not the principal residence. So those commercial properties or income property no longer qualify. And the last question is, I am planning to transfer my family home to my 2 children. Must the property become the family home of both children in order to receive the exclusion? And the answer is no, as long as the property becomes the family home of one of the 2 children within 1 year of the transfer. The property can qualify for this exclusion. Lastly, I just want to share with you some great resources that we have. Obviously, we have our website, but we also have, there's a couple of letters to the assessors that you can find on the State Board of Equalization website. There's 2 letters, numbers 2020/061 and 2021/008. And on these letters, you can find information. There's some great questions and answers that you can look at, and perhaps that can answer some of your questions. And now I'm going to turn it over to David.
Thank you so much, Nora. Really appreciate. Great presentation. And if you want to, there we go. Thank you. I'm going to start out with the first question. I'm going to be directing this to Larry. Most people did not understand Prop 19 on the ballot, and now that they are seeing what was hidden in it, they may want to reverse it by voting it out now. They see what it changes. Now that they see what it changes, any chance they can abolish it by vote now that they're waking up to what it really does?
Well, that's one of the problems with legislating in the California Constitution. because the only way you change anything in the California Constitution, unless there's a court decision that changes it, is by another vote. So I understand there are a lot of people that did not understand and not know what they were voting for with Proposition 19. In some cases, they were counterproductive or different, whether you were interested in the parent to child transfer or you were interested in the base year value transfer. But you'll have to change it. And in other words, a lot of people have asked us, well, how about the dates? The dates are so tight. Is there a way to change the dates that are in the proposition? And the answer is probably not, because it, again, as I say, it's embedded in the state constitution. The ballot measure was very specific as to the February 15th and the April 1st date. And so this is the problem with putting things in the California Constitution, particularly when they're hastily drawn and voted on, and very confusing, because the only way to change it is a vote of the entire population or the voters of the state of California.
Thank you, Larry. Nora, I'm going to address the next question to you, and that is, if a son wants to transfer a rental home valued at $950,000 to his parents today, can he do it without the house being reassessed?
Oh, hold on, let me unmute myself here. And so you said a rental home, correct?
That's correct, exactly.
Under Proposition 19, it will no longer qualify. Only the family home will qualify for Proposition 19 exclusion.
Okay, thank you. Another question, Nora, for you is, if a home has multiple units, can a child inherit the assessed value? Can the child inherit the assessed property tax base if they reside in one of the units and rent out the remaining units?
Okay. To be honest with you, we're still struggling a little bit with that. I am going to read to you a question from the State Board of Equalization. It's in one of those letters to the assessors that I mentioned in my presentation. It says, my father owns an apartment complex and lives in one of the units. He wants to transfer the complex to me, his son. Does the entire complex qualify for his family home? And the answer is no. Only the unit occupied as the family home qualifies for the exclusion. The remainder of the apartment complex would be reassessed as of the date of the transfer. So I guess the answer will be, it really depends. If the child, according to what the State Board of Equalization states, is that if the child resides in just one unit, only that unit will be, and it makes it the principal residence, only that unit would be able to be excluded.
Okay, thank you. Debbie, I'm going to address the next question to you. What if you sell your property and move out of state for 1 year and then move back and purchase a new home within the 2-year period? Does Prop 19 still apply?
Yes, that's fine. As long as it was your primary residence within 2 years of making your purchase of the replacement property.
Okay, thank you. And then the next question is also going to be for you as well, Debbie, which is, we are an unmarried couple and interested in selling 2 homes that we each now own separately and moving to one larger, more expensive home together. Can we both take advantage of Prop 19 tax breaks?
No, only one of you can. You can't combine it and allocate over to the replacement. No.
Okay, thank you. And now, the next question I'm going to be addressing to Larry, but before I do that, if people have questions in the final 15 minutes here, 20 minutes that we have, if people raise their hands using the official raise hand button, we will call on you to ask questions, and we will ask you to keep your questions brief and to the point. And we are not in a position where we can answer very, very specific sort of your own personal situations, but we'll do our best to try to provide a response. And as we put in our several times, I've indicated, where you can find this webinar, all the information that we have on our website, and how to email us. So Larry, the question that people have asked is, do you believe Prop 19 will create significant stimulus for additional real estate transactions in California? Do you believe certain counties within California will suffer as a result of accepting lower tax basis? Well,
it's really both. Let me give you the example. as I said, my house, Zillow says it's worth $3 million. So if I sell my house, that's assessed at $276,000, and the buyer pays $3 million, then Santa Clara County, where my home is located, benefits because the assessment goes up. If I then buy a $3 million home in El Dorado County or Modoc County or somewhere else, I'll carry a $276,000 assessment into that county. So that county loses. I'll have a $3 million mansion in Modoc County with a $276,000 assessment. So some counties will win, some counties will lose. The purpose of Proposition 19, as I mentioned in my presentation, was to create more transactions for realtors and therefore more commissions. That was what it was designed to do. And I think it will overall, except there's some counties that will be big losers and some counties will be big winners.
Okay, and before I want to take one question that I just saw in the Q&A, and it says, how strict is April 1 date? Due to some legal issues, I completed the first transaction in March, the second a few days before April 1. Any chance to make it work anyways? So the short answer is no. I mean, April 1 is April 1. That's a hard deadline. Assuming the property has legally conveyed to you, both you've sold, legally conveyed that to someone else, and you bought, and that's been legally conveyed to you. There is no way. I mean, April 1 is the official date. If you're doing it inside of Santa Clara County, and you're not buying up, then you could theoretically still take advantage of Proposition 60. You could also do Prop 90 in a limited number of counties in the state up until April 1. So with that, I'm going to now turn to our first individual. What I'm going to do is I'm going to start with Jen Holst. I'm going to unmute you, and then you will be followed by Sheila Kuanowski.
Sorry.
Jen, okay, Ms. Holst, are you there?
Yeah, can you hear me?
Yes, please go ahead with your question.
Okay, great. We have a seller who sold and is now married, buying a property together, supposed to close on April 1st. It is fine to take advantage of Proposition 19, even though it's two people buying and it was only one seller.
Debbie, do you want to take that?
Yeah, it's okay, as long as the person who sold is on title of the property sold and the replacement property also.
Yes, thank you.
Okay, now we're going to take Sheila, followed by John Elevisan. And I apologize, I'm going to be butchering people's names, so I apologize in advance.
No problem. Nora, I have a question regarding the child. Can it be a child who has a conservator taking title, or must they be 18 years of age as their primary residence with a conservator? Question one. And number two, if the property is a single family home and it has an ADU built in that's currently receiving rent, is there now an assessment required because the single family home has the ADU on it?
Oh, I apologize. I need to unmute myself. So yes, a child can take title of the property under a conservatorship. If there's a conservator in there, also a guardian. Of course, the house has to be obviously for the benefit of the child in order to qualify. And yes, it has to be their principal residence of the child. And then the second question, can you repeat that second question again? I'm sorry, I misunderstood.
If there is an ADU that was built years ago and produces some income, will that trigger a change in the tax base?
Well, it really depends when the transfer occurred, right? So if the transfer occurred on February 15 or prior to that, then it doesn't matter if the home produces income, because under Proposition 58, income property is allowed. However, if it is the transfer occurred on February 16 or after, then it no longer qualifies. It has to be the principal residence.
But that's not, the point is he's going to live in the single family home, but he attached to it is an ADU.
So only, like I said, that question that I read from the State Board of Equalization, so only the principal residence of the child will be able to qualify.
All right.
Will my tax go up because I have an ADU?
If the child does not reside in the property, the transferee, if it's not a transferee principal residence, only the portion where the child lives, the principal residence, is excluded could be excluded from reassessment.
So then the ADU would be assessed? Is that how it would work? Then they would assess the value of the ADU?
Potentially that could be a reassessment, yes.
But just that portion?
Correct.
Just that portion. That's correct.
Yes.
Thank you. It's a good question. And as you can tell, we are trying to understand and work through this
Right.
as best as everyone, as best as we can, with a very poorly written change to the Constitution. I'm going to now move to John Elevazon, and followed then by Jan Kirian Papula.
Hi, can you hear me?
We can. Thank you. Please proceed.
Okay, great. Thanks for taking my question. And I'm sorry if you've already answered this in a different way. My folks have a triplex down in Santa Monica. They occupy the main 3-bedroom unit. There's 2 additional 2-bedroom units. My understanding for tax assessment, the entire triplex just has 1 tax assessment attached to it. When they pass and the property transfers to me or to my sister, is only the unit that they occupy going to be subject to Prop 19, or will all 3 units be subject to Prop 19? And if not, how is the property tax going to be assessed on the 3 units separately? Thank you.
So like I mentioned on the previous question, and the question that I read from the State Board of Equalization, only the unit that is occupied by the parent, and also if the child, one of the children that would be the beneficiaries, occupies that same unit as the principal residence, that will be the only unit that could be eligible for the exclusion under Proposition 19. The rest of the units will not qualify, therefore there will be a reassessment. And like David said, we are still looking through that question. We believe that it was supposed to be a 1 appraisal unit. But like I said, the State Board is addressing that only the unit that the parent and the child, the principal residence, would be eligible for the exclusion.
And I would also add to that I think it's important to note, I mean, knowing a little bit about the market values in Santa Monica, just because I spent time growing up down there, you have to keep in mind the $1 million threshold. Right. So, you know, as values go well over $1 million, suddenly whether there's 1 unit, 2 units, or 3 units is going to matter less.
Absolutely. I just wanted to know whether it was going to be viewed as 1 property because of the way it's treated now, or there'll be some separate treatment later on. But it sounds like maybe it's not entirely clear. But I appreciate you answering my question as best you could. Thank you very much.
Thank you.
Thank you.
And the next person is Jan Kareem, and followed by Peter Mew.
Yes, this is Janaki Ram, and you guys did an awesome job. This is a lot of information. Thank you so much. So my question is, if I have a rental property, which used to be a primary residence before, and I moved to a different property and bought it for a much higher value, but I want to use the rental property basis in buying a new property, how long do I have to move into that rental property to stay there and sell it to use that basis for the new primary residence?
Nora, you want, or Debbie rather, excuse me, do you want to take that?
Is it clear? I also put it in the text.
Yes, it is. Debbie, do you want to take that?
Yeah, there really is no time limit. You just have to establish your residency. You have to be eligible for the homeowner exemption at the time of sale or within 2 years of purchasing your replacement property.
So I can just stay there, a couple of months or,
You have to establish it as your primary residence, yes.
okay.
I would look to the guidance that we have on our website and other places about what does it mean to establish residence. Again, the assessor is going to be looking at, was this essentially your principal residence? Were you really living there?
Okay, thank you.
Okay, I'm going to move to Peter Mew and then followed by Min Win.
Hi everyone, thanks for taking my question. So it seems like from what I read is if a homeowner already bought a new property and that property is already assessed at the new purchase price, and within 2 years, he can still sell the original home and apply to have the property tax reduced at the original base. Is that correct?
Can you repeat that question? I wasn't clear.
Yeah. So if the purchase of a new home happens first, and then the sale of the original home happens within 2 years, the property owner can still apply to reduce the property tax. Is that correct?
Oh, yes. Yeah. They have 2 years to make their both transfers.
Okay, great. Thank you.
Okay.
But one of them must happen after April 1st.
That's
In
correct.
order to qualify, yes, under the new rules, yes.
That's correct.
Okay, thank you.
Okay. Min Win, you are next, and you will be followed by Caitlin Vine. Min Win, are you there?
Yes, I'm here. Thank you for taking my call.
Okay.
I have a question. On my current property title, it has my mother-in-law as 50% interest and my wife and I as 50% interest as tenants in common. We went through a refinancing just 2 days ago, and the title is updated to pretty much my mother-in-law and my wife and I as all as joint tenants. So I understand as joint tenants, the share are equal. They're no longer 50%. So am I still required to file a Proposition 19?
The answer is no. And that is under Joint Tenancy Property Tax Rule 462.040. That it states that if somebody creates a joint tenancy with somebody else, the reassessment is postponed, even though there was a change in the percentages. So the percentage is postponed right now until the joint tenancy is terminated. So I would really highly recommend you to look at the property tax rule and look for the consequences once the joint tenancy is terminated among the three of you.
I'm sorry. Yeah, I did call the property tax, the county, and this is what the county was recommending, that I file a Proposition 19 form, because the percentage has changed from 50% to 33% between all the three people, and that's what the county was advising me.
You can file the form, but we're not going to utilize the form because the property tax rule, the joint tenancy property tax rule, supersedes.
So will my property be reassessed, or no, it won't be?
It will not be reassessed at this time. The reassessment is postponed until the joint tenancy is terminated. Like I said, I would highly recommend you to read the provisions on the joint tenancy property tax rule, which again is 462.040.
And that property tax rule can be found on the Board of Equalization website. And I believe it's did we put that in your slide deck, Nora?
No, I do not have that property tax rule.
So you can find it on the Board of Equalization website, and you just literally type in PTR, property tax rule, and then the number, and it will come up. Okay. All right, I'm going to move on to Caitlin Vine. And Caitlin, you'll be followed by Jaime Gonzalez. Caitlin, are you there? All right, well, I'm now going to move to Jaime Gonzalez next. Oh, nope, he just dropped. So I'm going to now move to Elena Elenalani Lam. Elenalani Lam, are you there?
Forgot to unmute.
Oh, no problem.
Okay, so if mom and dad got divorced 20 years ago and each one of them got their own principal residence, one parent dies, can he leave a property to both kids? And then when the dad dies, can he leave the property to the same two kids?
I believe I answered that question on the Q&A, but the answer is Proposition 58 and also Proposition 19 does not prevent from that to happen. So the child can inherit a principal residence from the parent, but then also, I'm sorry, from the mother, but then also from the father.
Would they still keep the tax base, or does one child need to live in one and one child live in the other?
Well, we need to apply the provisions under Proposition 19. So the child that is going to inherit one of the homes needs to make the home a principal residence.
Okay, but they can both.
I'm going to ask you, we're going to have to, I need to move on to the next question. We're getting into very, very specific territory here, and I really want to try to keep questions that are general and that would benefit a lot of people. So I'm going to move us on to the next person, please. Which is going to be Barb Francis, and you will be followed by George Gonzalez. And we're going to be wrapping this up in about 5 minutes in total.
Hi, you can hear me?
Yes, we can.
All right. So I'm not sure if my question is specific to these propositions, so I apologize if it's not. But if a child like I passed away and my child inherited the property, but sold it, does it transfer at the cost basis that I paid for it, or is it stepped up? It's not they're not going to make it their primary residence, in other words.
Stepped up. Stepped up.
Nora?
It's a stepped up basis.
Nora?
Yeah, yes, it will not qualify for Proposition 19.
Okay, thank you.
All right. Next question is George Gonzalez.
Hi there, can you hear me?
Yes, we can.
Hi there, thanks for taking my call. Hope that you guys didn't answer this, but I'll keep it quick. I have a client who sold the property. We closed escrow January. This was his primary residence up until about 2 years back, forced to take care of his father at his residence and made his property a rental. Now we sold that, and now he wants to buy his father's house, which he had lived in prior 2 years. So I guess establishing the single, his principal residence, it was until he had to forced to move out, and now we are due to close escrow on April 1st for this property. Can we still do the Prop 19 for his previous residence to now the new same price? Makes sense? So he sold his principal residence January 1st, but it was the only property he does own or owned at the time. Makes sense?
It would have had to have been his primary residence at the time or within 2 years of purchasing the replacement. So if it's been a rental for a couple of years, he may not qualify because of that.
Okay, so if only, I guess he was only there for about 3 months before forced to sell because he couldn't afford the payment. So, I guess he hasn't been there for 2 years, and we understand the gains on the financial side of it, but we're just curious if he was there 3 months before the end of the year, if that would be counted as his primary because he moved back home after his father passed. Because
well, if it was his primary residence within 2 years of making his purchase.
Okay,
yeah,
that answers my question.
Okay, thank you. We're gonna next question is Ramesh Bajar, and Ramesh, you will be followed by Sherry Panahai.
Yes, currently me and my wife, we own our home, and we are planning to sell it and buy a higher priced home, but we need our son to help in financing. So would the tax assessment commute to my son as well? I know the formula now. Thanks very much for clarifying all that, higher value, how to tackle it and whatnot. So that I understand. I just want to know if my son joins us in coming up with down payment for the new property as well, then does he enjoy the tax assessment that we carry currently?
Nora, do you
Yes,
want to?
the transfer would apply to the replacement property and he would benefit from that, yes.
But he would have to stay in that property, correct?
No, he doesn't have to stay there.
Because the parents would be the principal residents.
Yes.
Okay. Thank you so much.
You bet. Okay, Sherry, followed by Joseph DiGiovanni.
Hi, I had a question for Larry. I wanted to, I guess I don't know if I understand it correctly. So basically, Prop 19, if you sell your home and the step up, there's only that $1 million that goes to your child. Above that, it has to get reassessed back into your base.
Well, yes, but that's a parent to child issue, and only 1 million can transfer. Prior to the old way, you could transfer any amount of money or any value to your children, and it would qualify. Now it's just up to $1 million. So, and previously, and somebody asked on the chat, why did I vote for Proposition 19 then? And I did because to try to eliminate the example I gave with Jeff and Bo and then Bo Bridges, which I think was outrageous. But also because previously you could not only transfer your principal residence to your children, but you could transfer any amount, any valued property in addition to your principal residence. So if you owned a shopping center that was assessed at $1 million, but you owned it for 20 years, and the fair market value is 20 million now, you could transfer a $20 million shopping center in addition to your principal residence to your children. I think that's outrageous. And so the reason I voted for Proposition 19 was to eliminate what I described and what the LA Times described as a very significant loophole. I'm not sure I answered you.
No, you did answer. That makes sense, and I understand your vote, but I also think it seems unfair on the principal home that should be that limit of $1 million.
Well, the reason that occurred, as I mentioned, is that because of the base year transfer of Proposition 19 was so costly to lost property tax revenue, that the realtors, the sponsors of Proposition 19, had to look for another source of additional revenue to offset the loss of revenue on the base year transfer. And so whether it's fair or not, that was essentially the deal that was made in order to provide revenue to offset the loss of revenue.
Thank you.
Thank you. So we have 5 more questions. If Larry, if this is okay, and the rest of our team is okay, can we try to squeeze these in the next 10 minutes and go a little over? Is that okay, acceptable?
If there's no follow-up questions to the original question, if they're short, yes, we will stay.
We ask everybody to please we got 10 minutes. We're going to go a little over trying to get the remaining questions. So Joseph, you're next.
Thank you for your professionalism. Thank you for all panelists and great questions. A property is held in trust. Dad passes in 2016, and the date of transfer to the children is 2016. The children then sell the property 5 years later in 2021. Are the children responsible for back property taxes because they've been paying property taxes for 2017 through 2021 based on the lower assessed value?
No.
Thank you.
Thank you. Okay, next person up is Sheila. and you are then followed by Sandina.
Be very quick. Child inherits the property, lives in it as the owner occupied property, and then determines that they're going to sell it. Can they carry the base when they move on?
Yes, they can.
Thank you. Okay, Sandina, you are up next, and then you will be followed by Richard Parker.
Yes, hi. Hello, everyone. Can you hear me?
We can. Please proceed.
Perfect. Thank you so much for taking my question. I will be turning 55 November of 2025. How can I take advantage of this Proposition 19 if I want to sell my original house here in Santa Clara and buy somewhere else like Orange County or San Clemente? Can I purchase the replacement first before turning 55? And would that be within 2 years of selling the house here in Santa Clara?
Debbie, you want to take that?
Yeah, yes, you can. You just have to be 55 at the time that you sell your original property. But you can make the purchase first, as long as you don't sell until you're 55.
So I can purchase the replacement first.
Right, but it still has to be within 2 years of you turning 55 to sell your other property.
The key is when you sell your original property, you must be 55, and then everything else must be within 2 years of that.
Oh, so I cannot purchase the replacement house in 2023.
Yes, it has to be within 2 years. That's the key. All right, I'm going to move on to the next question. Thank you.
All right, thank you.
All right, Richard, you're next.
Okay.
And you will be followed by Catherine Garzon.
Okay. So if a home was transferred a couple of years back, parent to child, under Prop 58, will they be able to rent it in the future without it being reassessed under the current Prop 19 guidelines?
The answer is yes. As long as they don't change the ownership on title, they are under Proposition 58 provisions.
Thank you.
Okay, Catherine, you are up next, and then you will be followed by Lynn Sille.
Yes, hi. Parents are about 80 years old. They bought a home back in '87 for $28,000. The house is about $200,000. They're far away from the kids and want to bring them closer. Looking into expanding the current home, about 200-300, or maybe making an ADU for them. How can we take advantage of Prop 19 into the current home that we have and have the parents live there in ADU? There's nothing we can buy for them for $200,000, of course.
Ooh. I'm not sure how best to advise you on that. I think I would suggest contacting a realtor and seeking advice on that, because that's a complicated question. I think it's too complicated for this type.
Could you do just an ADU to be assessed for that part? Because if the home is expanded, it's going to be treated as, you know, the additional square footage as new construction, and we don't want to have to be reassessed. We're talking into just an ADU.
Yeah. Again, I'm not sure if anyone else, Nora or Debbie or Larry, if you have any additional insights.
Yeah, that wouldn't qualify under the base year transfer because it has to be a 100% purchase of the property.
Yeah, 100% transfer of the property.
Yeah.
Well, the one that is.
So I'm gonna in the interest. Catherine, I know
Yeah.
we have a limited amount of time. We're already over. I'm gonna move on to our next individual, which is Leanne Silly, I believe.
Hi.
Thank
Hi,
you.
this question is for Larry Stone. I just want to understand a little bit more about why Proposition 19. How do you understand Proposition 19 benefiting the realtor, and they're the one that pushing for it? I don't understand that.
Yeah, and I speak to a lot of realtors associations, and what they were trying to do, as I mentioned earlier, is to cause people that have lived in their homes for a long time, have a very low assessed value, want to move to all 58 counties, it's going to generate additional transactions. And with big increases in amounts. In other words, the commission on my sale of my house at $3 million is much greater than the commission on the sale if it was based upon my assessed value. So it supposedly, the purpose was to encourage me to sell my house at $3 million, increase substantial commission on the sale of that home. And then of course there'd be a commission on the purchase of another home, even if I'm carrying my low assessed value. So it was clearly sponsored by the realtors, and I believe for that reason.
I see.
All right, I'm going to move on to our final question. It looks like our final hand is Gloria Salud. And see if Gloria is still on. It looks like she is not there, and there is actually, excuse me, Freshta Kes and Christina Hood, and that's it. We have to wind this up. Yep, those are you two are the final two, and fortunately have to bring this to close.
Okay. We had a primary residence in year 2000 with our two sons, where their names were in the title. Then we converted to rental property and put it into trust. The trust required us to have our two.
Hello?
Hi, we lost you there for a moment.
Okay. Can you hear me now?
Yes.
Well,
yes, we can hear you. Please proceed.
Okay. If we again include their names in the title, does the assessed value change because of change in title? Or can we do transfer to their names without any change of the assessed value? And what proposition applies to us?
Yes, there is a change in ownership when you're adding people into title, whether they are the children or not. So it's subject to a reassessment. However, now you have to look as to whether the transfer qualifies for an exclusion. Under Proposition 19, again, the provisions are met, that then you might qualify for Proposition 19.
Even though originally their names were in the title, it only changed when the trust required us to have them execute quitclaims.
So you did change the title, a quitclaim, you're saying quitclaim?
Yes.
So you added them or you removed them from title?
We added them. If we added now, we removed them from the title before the trust.
Okay, so if you did remove them from title, like I said, it depends on the date of the transfer. It could qualify for Proposition 58, but if it is after that February 16, it could qualify for Proposition 19, but you have to meet all of the provisions.
Okay, we're going to need to cut off that question and move on to Christina Hood, I believe is our final individual.
Yes, my name is actually Greg, and I'm sitting in for Christina. Thank you for the great presentation, number one. The question is this: how will Prop 19 apply to buying into an extended care condo facility? Oh, did you hear me?
Yes, I think it has to do with a condominium question.
Yeah.
And a condominium, like a townhouse, like a single family home, they're interchangeable for our purposes because they're all places of principal residence.
Okay. Okay. So Prop 19 would apply for the purpose of transfer.
Because it's their principal place of residence. That's
Great.
correct.
Thank you.
Thank you all very much. We're going to bring this to close. We went over a little bit. I appreciate everybody staying on for so long. We will have, as I've indicated in our in the chat and everywhere elsewhere, we have an abundance of information on our website and we will be keeping that updated as we get more information. I should also note that we immediately following this, there will be a survey that will be sent out to everyone, and we encourage you to provide feedback about how we did today, because we're trying to continuously improve. We've done quite a few of these webinars, and so we're continuously working to make these better product. As Larry mentioned, we're probably approaching 5,000 people who have participated in one of these or have registered to participate. And with that, Larry, I'm going to turn it over to you to close it out.
Well, thank you very, very much. You can tell by the number of people on this webinar and the ones we've done previously, the level of interest. In fact, in my 26 years as the county assessor, I wasn't the assessor when Proposition 13 passed in 1978, although I was a young council member in Sunnyvale. I can't imagine that any issue I've encountered in the years I've been the assessor that has generated as much both interest and confusion as Proposition 19. Hopefully, the Assessors Association, working with the State Board of Equalization and cooperation from the state legislature, that we will bring much more clarity to how this is being interpreted and implemented. So please stay tuned, as they say. Well, thank you very much, and we enjoyed doing this in behalf of my office. I want to thank each and every one of you that was on the call today. Thank you.